All right,
Okay,
go for it. So we're moving from marijuana to sexual harassment. So keeping the
Our favorite topic,
keeping the hot topics going.
So there's been a a new development in well, everyone knows about like the Me Too movement and how important it's become. Obviously, it's always been important, but how it's been in the spotlight recently. In addition to this, I also wanted to mention that this law, which I'll get into in a second, basically just says that if you settle a case or any kind of complaint based upon sexual harassment or sexual abuse, you cannot have a confidentiality provision in that agreement that says, hey, we're settling this out with you, but you cannot talk about the facts underlying your complaint. So that's what this law does. Earlier, when President Trump passed the tax reform, which was effective at the beginning of this year, there was a provision in there that said that companies or employers can no longer write off, attorney's fees as well as settlement costs that are subject to a complaint for sexual harassment or abuse if there was a non-disclosure agreement in that agreement. Or a non-disclosure provision in that agreement, I should say. So for instance, if you have a settlement agreement, if you have an employee who complained about sexual harassment, you settled that, claim with an employee for, $5,000, I'm just making that up, $5,000. You also paid your attorneys, $10,000, whatever it is. And in that agreement, it says you cannot talk about the facts of your complaint and you cannot talk about this agreement. If you have that in there, the new tax reform says you cannot deduct as a business expense the $5,000 settlement or the $10,000 attorney fee. So what this does is it takes it a step further, because that basically does not prohibit you from doing it. It just gives you a financial disincentive to do so, right? Well, what this new statute does is it says that parties to a settlement agreement cannot agree to keep the facts of the the underlying issue confidential if it relates to discrimination, sex discrimination, retaliation for reporting discrimination on the basis of sex, as well as what would be a sexual offense pursuant to Nevada law. So it also protects the claimant's identity. So basically, you can't, as long as neither party is a government agency or a public official, you have to protect the claimant's identity. So basically, what this is it's the law telling you that, look, if there was a complaint for sexual harassment or abuse, you cannot sweep that under the rug and keep it under wraps, right? You can't kind of gloss over it and make the person promise that they won't talk about it. That's the bottom line. So in addition to the tax disincentives, there's also a prohibition on doing this as well. This is pretty straightforward. Is there any questions on this? Okay. So I'm sorry, one last point, I apologize. So if you do have a settlement agreement, and of course, your friends at Advanced Staff as well as we can take a look at these agreements for you. If you have a settlement agreement that deals with allegations of sexual harassment or abuse, we would say please do not include a confidentiality provision in there. Also, you could in other agreements, so if you are settling a case or a claim that is based on something other than sex discrimination or sexual harassment, you could include a provision that says, you agree that your complaint has nothing to do with sexual harassment or abuse or sex discrimination. And that way you can say, now you can keep the facts of this confidential because it has nothing to do with sexual harassment. If that makes sense.
Right. That's a good rule of thumb now to add into any sort of severance agreement, separation agreement, settlement agreement. Specify that there are no allegations of sexual harassment, discrimination based on sex or sexual abuse, so that you can include a confidentiality provision in that agreement. Otherwise, you're going to be subject to this new statute. All right.